You're watching HFO TV.
First, I'd like to introduce Chris Robinson, Lake Oswego attorney. He's been practicing for over 35 years, and his focus is representing clients in complex property tax situations. In 1987, he formed Property Tax Analytics Incorporated, a property tax consulting company. Today, Chris is going to talk to you about apartment property taxes. Please join me in welcoming Chris Robinson.
Thanks, Greg. Thanks to the HFO team for the opportunity to speak to you today. My world is property tax, and it's been a very interesting last 4 years with the events that took place in 2008 and sent reverberations throughout the real estate markets across the country. Give you an idea of what happened to market values in early 2008. I had a client pension fund that purchased a property for $140 million in March of '08. At the end of '08, they had an appraisal done. That appraisal came in at $98.5 million. So over $40 million of market value that evaporated. With Measure 50, you might ask, well, why do I even care about market value? Because my taxes are not based upon market value. They're based on an assessed value that's a creature of Measure 50, which came to being in 1997. This is the only jurisdiction I know where property values can go down and your property taxes can go up. You've probably experienced that. One of the things that I'd like to leave you, I should go back and talk about appeal trends. It's interesting. For example, Multnomah County has 345,000 tax accounts that they're responsible for. The last couple of years, maybe the appeals have been in the low 2,000 range. So less than 1/10 of 1% of tax parcels get appealed. And it's the same in Clackamas and Washington County. Less than 1/10 of 1% of the total accounts get appealed. The reason that we care about market value is a concept called compression. And in high tax rate counties like Multnomah, Washington, and Clackamas County, where the tax rates are above the Measure 5 tax rate. If you remember Measure 5, $5 for education, $10 for general government. Well, we have, in those counties, surpassed that. So there is, if we could go to slide 3, I believe, it's the tax statement. Here's a tax statement that kind of illustrates what I'm talking about. Under compression, if I can get a reduction in market value that's still above the assessed value, I can create tax savings. So that's, when you get your tax statement in October, you should be doing an analysis to see, or send it to us, to see if it would qualify for compression. And what, in this example here, if we go to, you can see here that the education taxes are, and this is in your hard copy handouts as well in the back. The education taxes are about $20,000. The general government taxes are about $40,000. Well, in our hypothetical, if we go to slide 4, the compression calculator, in our hypothetical, we get the market value reduced to $3,500,000. It's still well above the assessed value of, can't see it over there, just over $3 million. However, because we got the reduction in market value, we get a lower tax if we use the Measure 5 tax rate on the real market value. And in this case, we produce an overall tax savings between the education portion and the government portion of about $7,200.
Chris, I don't understand that. I thought everything was based on the assessed value.
That's popular, you're not alone, Ken. It's a popular misconception that Measure 50 just made market value irrelevant. Right. The fact of the matter is it doesn't, because Measure 50 didn't replace Measure 5. They coexist together. So if you use the Measure 5 tax rate on the market value, your RMV, real market value, and come up with a lower tax for education and for the general government, you're eligible for some compression. The second, I think, trend that I would have you look at is in the change property ratios. Measure 50 had to have a mechanism to bring new construction on in some kind of parity with existing properties. And if we go to slide number 5, you will see here some interesting trends. So if my property wasn't in existence in 1997, when Measure 50 came into existence, we had to have a mechanism for new construction. And each class of property, the Measure 50 created classes of property, and you see you have residential, you have commercial, you have state industrial, and you have multifamily. If you look, and again, you have a hard copy of this, but look at the trends in the change property ratio, for example, for multifamily. We'll focus on that. Multifamily, the CPR in 2007 for Clackamas County was 67%. In 2012, actually last year, 2011, the previous tax year, it was 89, almost 90%. So that means that if you built a new project and it was $10 million in market value, your assessed value in 07 would be about $6.7 million, and your taxes would be based on that. But if you were unfortunate enough to build it in 2011 in Multnomah, or Clackamas County, your assessed value would almost be $9 million, and your taxes would be substantially more. So, and this has happened across the board in Clackamas County. You see that the CPR has increased. And so if you are developing or looking at developing, you need to look at the different CPRs in the counties. Because Multnomah County, the CPR for multifamily currently is just under 60%. So you have Clackamas at 87%, you have Multnomah County at 60%, Washington County is down around 67%. So interesting that if the goal of Measure 50 and the CPR was to bring new properties on in some kind of parity with its existing property, it's not accomplishing that function. You could have comparable projects with considerably heavier tax burden. The other concept that I'd like, I don't know how many of you have developed properties in the last, say, 5 years, but if you're looking at developing a property and it's a fairly sizable project, there is a new construction exemption that is available to exempt the value on the improvements while you're under construction. Many projects do not qualify because one of the requirements is that your construction period has to last at least 12 months. So if you're under 12 months, you don't qualify. But if you are going to be, or if you think it's even going to be close to 12 months, it's a good idea to file the application. Those are due in April, by April 1, for the following exemption for the following tax year. And so there's no real downside. So if you think it's a close call, you should file that exemption. In terms of deadlines, I think you probably are familiar with the process here in Oregon. The appeal deadline is December 31st. It's great timing. The holidays makes our office kind of a fun place to be. And then the hearings are held in the spring, starting February, winter, spring, wrapped up by mid-April. Then you have a second level appeal to the Oregon Tax Court, Magistrate Division. That was set up actually to replace the Department of Revenue, who used to hold the hearings, and you would appeal from the county to the department, and the Department of Revenue had those hearings taken away from them because they were doing bad things. For example, the taxpayer, the hearings officer would write a decision in favor of the taxpayer wins, and it would go up to a supervisor to review, and the supervisor would change it and say, taxpayer loses. Taxpayer would never know. So actually, some of the hearings officers that worked for the Department of Revenue at that time came into the legislature and testified, and that was a very uncomfortable time for the director of the department who was sitting there. So the Magistrate Division was created to replace them, supposed to be low cost, user-friendly, informal, and it's kind of morphed into very formal, not so inexpensive, and not so user-friendly. The filing fee for tax court is $240. So That's kind of an overview of the process. Okay, there's some case studies in the back, the last page of this handout. And it's just the kind of different settings that you can have a multifamily or an apartment appeal. One was where the property ended up going back to the lender. It was going through a condo conversion process. Market cratered, ran out of money, and not only did the lender get the property back, but it had serious physical problems. Extensive dry rot water penetration issues to the tune of several $1 million. We were able to get a 3-year reduction because they were still platted as condos, and there's a unique feature in Oregon law where you can appeal not only the current year, but the prior 2 tax years if you can prove a 20% or greater error in the market value that would result in a refund. In that case, we obtained a refund of $120,000 for that client. Another case, the property was just overvalued. Simple case of overvalue. What do we look at? Well, we look at your operating history, we look at your rent, income stream, we compare that to market rents, but assuming competent management, we more or less assume that you're at market, unless you tell us something that, hey, I'm keeping the rents low to keep my occupancy up. We'll look at your expenses to see if there are any anomalies. We'll then focus on net operating income, because the direct cap approach is really the dominant valuation method for multifamily. And we'll compare that to the roll value, the real market value. And in some cases, and especially in the rural counties, we have got a market value below the assessed value. And in that case, they become the same. Your assessed value and market value are the same, and you're taxed on that value. The new construction, when that property does come on the tax roll, it's absolutely critical that you monitor the market value, because when you apply the CPR, that's going to be your permanent tax base. So if you miss that year, it is extremely difficult, unless some later year you qualify for compression, extremely difficult to move the ball down the field to lower your property taxes. Thank you very much.
Thanks for watching HFO TV. To learn more about HFO, call or visit our website. See new listings, apartment news, videos, and more when you download our apps at the Android and iPhone markets.